Good morning. All right, we have another great provision of analysis by the wonderful attorney Adriana of the Tower Law Group. And she has dissected a recently published case out of the 11th Circuit, Social Security case. And this really drives home what we are always kind of nagging, so to speak. Whoops. Sorry about that. About, gosh, guys, you really have to have your choices and actions coincide with what you're claiming in a Social Security case. So this case is called Carr, C-A-R-R versus Commissioner of Social Security. I will put a button to it, to the actual narrative of the case at the end of this. So if you want to look at the synopsis in writing or the entire case, you can. Okay, so let's see here. I gotta brighten that up so I can see it. Okay, this just came out in January of 2024, guys. It's really, really fresh. It is 11th Circuit, which does not then apply to everyone in the country, only those within the 11th Circuit. However, as I pointed out before, it is not uncommon for a decision of one circuit to be unofficially, at least, embraced by others, because sometimes it has much logic and common sense to it. So while officially it doesn't mandate anything elsewhere, it can definitely be something to consider. Okay. All right. So in this case, a denial by the SSA was upheld by this court. And it has to do with subjective symptoms that someone is claiming, along with their daily activities that they've acknowledged, and how that can be evaluated, and how there is a interplay with the objective evidence that's available in the medical file. So the big take-home point may be your subjective complaints, and what you're doing in your private life, such as that which you would include on your function report, or that you share with your doctor and it ends up in your medical records, should jive with and not appear to be inconsistent with the amount of pain or limitation or symptoms that you're claiming in your case elsewhere. So here, the ALJ had decided that, and this is when he's looking at the claimant, Mr. Carr's testimony. He concluded that Mr. Carr did suffer from degenerative joint disease, carpal tunnel syndrome, disc disease, headaches, hearing loss, and bipolar disorder. However, the ALJ found that Mr. Carr's testimony about the intensity and limiting effects of his symptoms were just not consistent with the medical evidence, as well as the daily activities that were revealed throughout the case. The ALJ had apparently detailed the medical evidence, including x-rays, scans, and examinations that contradicted the claimant's claims about the severity of his impairments. So some of those more innocuous x-rays, things that are could be unremarkable, well, that would be like flat out negative, or very, very mild, depicting mild impairment or findings. Those can be damaging, right? We want diagnostics, but they have to kind of confirm. So from an objective standpoint, they did seem to find that the diagnostics themselves contradicted his claims. So that would suggest to me, meaning his claims of severity, that would suggest to me that the diagnostics were mild. They don't specifically say that, or Adriana doesn't in her terrific synopsis here. But that's what I would get a take from it, and I have not read the case yet. The ALJ had also highlighted inconsistencies between the claimant's assertions and those most recent examinations and imaging. And when they say recent examinations, I would take that to mean a physical examination that our doctors do every time we go to them. Sometimes they're very cursory and very short. But when our doctor does them, and particularly if they're cursory or short, and it does not note any severe findings, then that's going to be something that's going to contradict claims of severity. And this is an aside from me, not from Ms. Adriana or the case. When our providers, a lot of time it's a computerized system where they have a whole list of things that are apparently under a physical exam. I don't know that I have reason to believe that they don't actually check all of those things on your body, but they answer as if they did within normal limits. So it seems like if they don't check it, it's going to be defaulting to within normal limits. And therefore it's going to be clearly inconsistent with something that you said elsewhere as a claimant as to a symptom that's arising related to that. So these very lazy ways that the technology has allowed medical providers to create records are often strewn about with inconsistencies and saying something's within normal limits that was actually never checked. There's a lot of problems with that. And there's a lot of news going on about that as well. I mean, particularly in my field. So I'm not saying anything new here. And unfortunately, it's a sandbox we have to play in. So it might behoove claimants and patients to look at every progress note after every visit, as soon as it gets published up in your portal, for instance, and see when it's fresh in your mind as to what you discussed with your doctor, and whether or not did he actually test your musculoskeletal system that day, or was he just taking your temperature because you have the flu? And maybe bring up, this is incorrect. You never checked my this, that, or the other thing. Okay, so going further along with this particular case, they noted that, or the judge, I would say, remember the ALJ made the decision and supported it XYZ ways, and then they appealed it because the claimant lost, and it went to the 11th Circuit, who is now evaluating whether the judge did things according to law. They're not so much making a substance decision on whether the person's disabled or not, but whether or not what the judge was looking at and how he evaluated broke any rules, or failed to comply with something he had to do, or did something that he was not allowed to do. Okay, so they also looked at the daily activities, which would often be found in the function report, and this lent itself to findings of credibility with the claimant. It said that the claimant's daily activities included caring for his children, attending sporting events, performing household chores. Now, that's why it's very important in your function report to describe how limited they are. If you're doing any household chores, and if they are limited and they're not like they would be with a normal person, or maybe the you before you became disabled, that's the part you have to really drive home. I know you may have a representative who doesn't help you understand the function report as you're filling it out, and that's unfortunate, but you really, we do it totally differently. You have to explain to them on there how it's different, not just that you do laundry. What if it's that someone's carrying your laundry basket to the laundry room, and you sit on a stool and you put it in the front loader, and that's all you're doing? You're not getting up and over and in, there are ways to explain it, and sometimes better detail when it's something that's limited and not done in a normal fashion would be really important, in my opinion, to include. So the judge scrutinized these daily activities that were probably described in his function report. And he noted, the ALJ noted that the activities described by the claimant were more extensive than would be expected from someone claiming an inability to work. And of course, that is what contributed to the determination that he could engage in sedentary work, which is apparently the basis upon which he was denied, because he could do sedentary work and there was no rule that provided that he'd be disabled even if he could engage in sedentary work from an exertional standpoint. We just did a video on the exertions if you need to see it. Caring for the children. I'm always very, I always advise my clients to be very careful when they're talking about, and this is in the earlier part of the function report, Do you care for others? You know, again, focus on how differently you care for your children if you're the one doing the day-to-day. If they are teenagers and you never have to do anything physical, make that clear. You know, if you just say, I care for my children, that's a pretty open-ended thing. I know I have a video on that whole question. And here's and I think someone busted my chops for it, saying, oh, this is so petty, this question, and who cares how you answer it. Bingo, this guy just got denied, with that being one of the crumbs the judge used to deny him. So, you know, I know some people don't want to think they have to be very careful on each and every question in a function report, but it's not true. Okay, attending sporting events was another thing that ALJ brought up. I find this one to be a difficult one to swallow also. When we attend a sporting event, now, unless it's like at the local elementary school or high school, like it's your kid's sport, in which case you would probably want to make that clear. And if you have to go take a break and go outside and sit in the car part of the time, make that clear. All the ways you don't do it in a perfect manner. But if one is talking about a major sporting event, like driving an hour, 2 hours to the big stadium, Yankee Stadium or Giant Stadium, I'm East Coast, can you tell? And then you're waiting for an hour in the seats, in those uncomfortable seats for the game to start. Then you got 2 to 3 hours for the actual game. And then you got to muzzle your way out of there and then sit in traffic to get out of the parking lot and then get on the highway and go home. That's a long day of not being able to go rest your body for that pain. If you're saying you have, aggravated pain very quickly, that would be a rough one. If you did attend a sporting event and it was a disaster and you had to recover the next day and it really aggravated your pain for more than 2 seconds, I'm not, you're not going to be dishonest about the fact that you went to a sporting event, but, if the question's asked, but certainly explain the repercussions. So it didn't seem like that's something you could do again or would willingly do again. Capish? Okay. The claimant argued back that the ALJ had merely summarized the treatment notes in the record and had failed to explain how the treatment notes contradicted his testimony about his pain. He contested how his daily activities were characterized by the ALJ, and that they were characterized as demanding type of activities of, daily activities. Because his position was that these activities were too easy to support a finding of not disabled. Like, they're very easy and simple. That might have been something he did on appeal, but if that wasn't in his function report that way, that's kind of a little convenient to just argue on your appeal. And apparently the 11th Circuit didn't take it to heart. And I would guess that's probably because he didn't describe at any time earlier, at least not sufficiently, if at all, how the activities that he was doing were done in a way that would make it super easy. Like I go to, when I care for my children, I ask them if they did their homework and make sure it was done. It doesn't necessarily mean you're changing diapers, bending over a 4-year-old, getting him ready for preschool, putting him in his safety seat in the car, carrying him out of the safety seat in the car. These are all things that you want to make sure it's clear you're not doing if you're not doing them because of your symptoms. Okay? Because otherwise the presumption is you are hands-on. When we care for kids, everyone who's done it knows it's very, very hands-on unless it's not. And the only reason it wouldn't be hands-on would be because of a significant impairment to being able to do that, right? So you got to make it clear. The onus is on the claimant for all of this. This is not something that, they're going to presume you can't do squat unless there's proof that you can't, or that you can. No. The burden is on the claimant, not on the SSA for this particular type of information, because the claimant is the only one that can provide it, right? In any event, the 11th Circuit disagreed with the claimants, and they used the, quote, substantial evidence standard, which is a very difficult standard for a claimant to disprove. It has happened. We've done it, but when it's been really egregious, you know, the discretion, of course, is appropriately with the ALJ. The court apparently emphasized that there was a thorough examination of medical evidence and the daily activities, which supported the conclusion that the claimant's symptoms were not as severe as he had claimed. So the court found that the ALJ was thorough and not just summarily making statements as contended by the claimant. And as Attorney Adriana says, this case underscores the importance of aligning subjective claims with objective evidence and daily activities when seeking disability benefits. Gotta underscore that, which she does. Quote, this case underscores the importance of aligning subjective claims with the objective evidence, that's your diagnostics and your medical records, and what the doctor is finding in his physical exams that he's writing down, as well as the daily activities that the claimant himself or yourself is putting in any of those statements that have to get submitted. So remember, your statements on daily activities is your function report. It could be things that you allegedly stated to your doctor and he put them in the records. You know, he went to a country line dance last weekend and he was a little sore after. That wouldn't look so good. Yes, he was sore after, but a little sore after? Those of us that aren't disabled to be a little sore after, potentially. So you got to be careful. You know, those loose lips sink ships. But also being able to do that could very well mean that your symptoms are not as severe as you claim, or who would be choosing to do that? You know, even if you did love line dancing, you know, you might be, when we get impaired and we're fearful of the repercussions of aggravated pain and how long it takes to mitigate that pain, you know, it's not a choice most people make. That would be, I think the human nature aspect that we expect is that if you're in daily or multiple times a week in the severe pain you talk about based on mild activity, you'd never be choosing to do mountain climbing, maybe line dancing, all those things, you know, things that are very active. So anyway, apparently this court well explained it, and so did Attorney Adriana, who did a fabulous job, and I love it when she does this because it helps me to learn things that I otherwise have to spend a few hours delving into that case law for. So, and I wanted to share it because I always tell my clients, these things are important. Don't take that function report lightly. Be careful what you say to your doctors, and it wouldn't hurt to, yeah, stay on top of what your doctors are saying in your medical records. Now that we have portals for many of the providers that are in big health networks and some of them that are in small, while some still haven't gotten up to speed, they have portals, but there's nothing in there. The big ones are following the law that says the progress notes have to be put up. So I would use that. The progress notes are very, very important, as are the diagnostics that will be in there. So look at those reports. Mild findings tend to be taken as mild, mild, mild. There are other, you know, terms of art that you might like. Moderate or severe can be a little more helpful. And of course, then there's like just terms of art in the medical field in diagnostics that are way heavier than others. Like degenerative disc, not so much. Maybe if there's a severe in front of it, it'll be helpful. Spinal canal stenosis is helpful. That can be mild, or it can be severe, or it can be moderate. The stenosis itself is helpful, and obviously moderate or severe is more helpful than mild. All right, guys, that's it. Carr versus Commissioner of Social Security. Excellent explanation, and I thank Attorney Adriana of the Tower Law Group for, again, generously sharing her analysis. Take care, guys.